Okay, this is the module, an online lecture for torts. So if you're listening to this, um, this is being recorded for Southern New Hampshire University, MBA 610 Business Law, and we're going to launch right into this. And hopefully what we'll do is post this up on YouTube, break it down into a couple of different lectures so that you can watch it all as a single playlist. And that also makes it easier to kind of organize to go back and find certain sections that you want to review later on. So I'm recording this with a Mac program called iShowU, so you might see my mouse like this kind of flying through the screen from time to time. And hopefully this tends to work pretty well, so I don't think there'll be any problems, but let's just roll the dice and see how we go here. So to start off, what are we talking about when we're talking about torts? Now, my favorite personal kind of tort is the chocolate one, but unfortunately, we're not talking about that kind of tort here. Tort is a different area of law that originates out of common law. And loosely defined, a tort is a civil wrong for which the aggrieved receives a remedy in the form of damages. There's lots to explain in that really quick definition. There's lots of little terms that need to be explained a little bit further. But the important thing at this point is to understand that what we're talking about is the personal injury type cases and some other types of cases. But I literally mean the, have you been injured in an accident, call me now for a free consultation commercials that you see on television. It's that kind of a case. So we're talking about people who've suffered some kind of injury or some kind of loss, and it's a civil wrong. And we'll get into the difference between civil wrong versus some others, and we're also going to talk about damages. So first, the concept of a civil wrong. All right, a civil wrong is a wrong that's to an individual as opposed to a wrong recognized as a wrong to society. A wrong to society at large is considered a crime, a criminal wrong. And those are punished differently, they're prosecuted differently. That's why when you see a crime progressing through the criminal justice system, the case is always the people of the state of New York versus Smith, or State versus Jones, or whatever. That's the title of the case that's progressing in the system, because it's the society that's been wronged in that case. Because there's some criminal statute that's determined whatever this person's alleged to have done is a violation against society. In this case, a civil wrong means that it's an individual, not necessarily society. It's a private matter. Not in the sense that it's secretive, but just in the sense that it's not a public harm that's been done. Alright, so that's what we mean by a civil wrong. So of course, we have a criminal justice system, and we have a civil justice system. And in this course, I think as I mentioned, we are going to be primarily focusing on civil law. We're really not going to touch on any criminal matters, because even though it is possible for businesses to commit crimes in very rare circumstances, and we'll talk a little bit about that later on, for the most part, criminal law is not necessarily something that's broadly applicable to business law. So I know criminal law is something that can be really interesting and exciting, but we just don't have time for it in this course. So we're sticking to civil wrongs, and in this case, in torts, that's all we're talking about. So in torts makes up a huge chunk of the civil wrongs that are typically brought to courts, to trials, to litigation to be remedied. So the other part of this definition that I think needs a little bit of explanation is damages. Damages is going to be used in the course of this presentation to mean a couple of different things. It's a pretty broad term to begin with, but even as we use it in talking about torts, it means a lot of different things. For example, we could say that in order to, and we're going to get to negligence in a little bit, and we're going to find out that damages is one of the requirements for negligence. And what we mean by that is that somebody has to have suffered some loss. Something, whether it's a personal injury, you broke your arm, you busted your head, you broke your leg, you got really sick. Those are all some type of personal injury. Or it could be a loss of property. Your car got smashed, your house burned down, somebody cut down a tree in your yard, something like that. That's damages in that context. Another way we could mean it, and the way it's kind of meant in this definition, a remedy in the form of damages, we're actually talking about cash. We're talking about money. We're talking about financial restitution. So when you think about a tort, you're talking about a wrong for which the person who's a private wrong, and it's one person against another person, or at least in some cases one company or a business against another business, or a person against a company, or a company against a person. But we're talking about somebody trying to get made whole for some loss by recovering money or something of value from the other person. So again, another huge difference between torts and criminal. In the criminal process, there is something called restitution that can be assigned as a crime, assigned as a punishment for a crime. So for example, a lot of times in cases of vandalism, one of the sentences that will be handed down on someone who's found guilty for vandalism is to pay some sort of compensation or restitution for whatever it is that they damaged or destroyed in the course of their vandalism. But for the most part, that's rare in criminal law. Most of the time, the crimes are going to be punished through, well, you know, I mean, imprisonment, what's the word I'm looking for here? Probation, or, you know, possibly fines and that sort of thing. But even then, in those cases, the fines aren't going to be weighed based on what the victim of the crime suffered. It's going to be based on what the law says a proper fine for that punishment should be. Classic example is a speeding ticket. Your speeding ticket fine is not based on the actual harm or damage that you caused. It's based on what the law says. Speeding ticket shall be this much for X number of miles per hour over the speed limit, or whatever. So, very different situation in that case. But so damages has a bunch of different meanings. It could mean the actual harm being caused. It could mean actual dollars in restitution. And you have to ask yourself, and we're going to see that word a lot in this course. It's going to come up all the time. And you kind of have to understand the different meaning of it. It's one word that can have a bunch of different meanings, a bunch of different contexts, depending on how it's discussed. So when we're talking about a tort, and each one of these, we're going to talk about a bunch of different types of torts through the course of this lecture here. We're talking about something that's a civil wrong, and one person who's been aggrieved by it is going to want to seek a remedy for that wrong against them in the form of damages, and in this case we mean value, money. Alright? So that's a tort. Another way to talk about torts as an area of law is to say that it's a collection of causes of action. Now, cause of action is an important term in the law. And I'll give you an idea of what it means. And I'm gonna illustrate it with a little story from my own experience. When I first got out of law school, and one of my first job practicing was in a civil litigation firm, so I was a trial lawyer, and I was as green as you could possibly be. I mean, the joke they always say is that you come out of law school and you don't know where the courthouse is. Well, I literally did not know where the courthouse is. Had to look it up on like MapQuest or something. So really, really green. And when I took over for an attorney who had left the firm that I was joining, I took over a batch of cases that attorney left behind. One of the cases involved a bunch of students who had attended a school, and it was kind of like a community college or a junior college kind of situation that offered a bunch of different courses of study. And one of the courses of study they offered was massage therapy certification. So maybe there were 8 or 10 students that signed up for this massage therapy certification course. And it wasn't a course. We had to take multiple courses to get this certification, but there was you guys know how this works. You're all in a program where you know exactly what classes you have to take in order to get the degree you're seeking. So it was the same kind of deal. And I think it was like a year or year and a half study to get the certification they needed, and they had to take a certain number of courses. And the school hired one teacher to teach the classes that were specific to massage therapy, and some of the other courses they had to take, like human anatomy and some other things like that. They had other teachers teaching those courses because they were applicable to a couple other disciplines. Anyway, so they went through this massage therapy, these students went through this massage therapy certification program. And then they got out and they got their certification and they started to get jobs. And one of the students got a job at a salon or something, and on the very first day of work went in to handle her very first client. And the supervisor or the owner of the salon or whatever said, "I'm going to come in and just observe to see how you do this." She said, "Okay, great, fine." So the client's on the table or whatever, and the student, the new massage therapist, goes in and starts to do her thing, and she's, doing the massage the way it's supposed to be done or whatever, and the supervisor comes over and says, "Excuse me, what are you doing?" And she says, "I'm doing this technique, I'm doing that." And she says, "That's not how you do that at all. You're doing that incorrect." And she says, "Oh, that's very okay. Well, I'll do something else." And she started to do something else, and the supervisor said, No, that's incorrect. You're doing that completely wrong, and you don't know how to give a massage at all." And she said, "Well, of course I do. I went through this program of study, and I learned it. I have my certification." And the owner of the salon said, "I'm sorry, I can't employ you if you don't know what you're doing." And she fired her. And so she was very upset, obviously, and called up a couple of her classmates that she'd taken all these courses with and said, "This is the way we learned how to do it, isn't it? I'm doing it right." And her classmates said, Yeah, you're doing it. That's the way we learned it." But she also found out that a lot of her classmates had a very similar story. And they started to figure out that they hadn't actually learned the correct way to do it at all. They had been taught incorrectly. So they were pretty upset. And they wanted to sue the school. And the firm that I worked for took on this case. And now here I am, I think I was 24 years old, and brand new bar license, and now this case lands on my desk. And I feel for these students. Probably because as someone just coming out of law school, I felt like I didn't know what in the hell I was doing either. So we had a lot in common. But I felt for them, and I said, well, this obviously wasn't right. They've been taken, they paid tuition, they went through all this time and effort and energy and stress to pass these exams and take these courses, and then they got out and find out that it really hadn't been worth their while at all. That's disappointing. So I took on the case, and the very first thing I had to handle was that the school and the attorney for the school had filed a motion to dismiss the case. And the motion to dismiss the case was based on the fact that there was no cause of action for educational malpractice. Now, there's legal malpractice. That's a cause of action. So if your attorney does a terrible job and it costs you money, and they mess up your case or whatever, or they miss a deadline and your case gets dismissed, you can sue your attorney for legal malpractice to recover for his poor job. There's medical malpractice, same thing, applying to doctors. There's even engineering and accounting malpractice in some states, but there is no such thing as educational malpractice, especially in Florida, which is where this case was taking place. So I did a lot of research and sweated a lot in preparation for this hearing, my very first motion hearing in front of a very real judge in a very real case in a very real courtroom against a very real attorney who had a lot of very real experience compared to me. And I go in there, and my argument was going to be that this was not a case for educational malpractice. This is a case of breach of contract. And we're going to talk about contracts if we haven't already. We talked about it a little bit, but we're going to get into it a lot deeper. And you know that when a contract exists, if one party doesn't live up to their obligations under the contract, the other party can sue them. And that's a cause of action called breach of contract. So that was my argument, that there was a contract between the school and the students. The students agreed to pay, the school agreed to teach them, and the school did not live up to their end of the bargain. So I go in to argue this, and the judge says, well, I don't know, Mr. McBride. It sounds to me like the school in this alleged contract, assuming that it is a contract, the school only promised to offer these courses, and that if they completed them and paid their tuition and did all that stuff and passed their exams, that they would receive a certification, which they all received. So in what way did the school not live up to their obligations? And I knew what the judge was setting me up for. The answer to that question cannot be they didn't do it good enough. Because not doing it good enough is another way of saying malpractice. And if I had answered that, he would have said, no, that is not a cause of action. So I said, well, Judge, they intended to offer these, they said they would offer these courses, but in reality they didn't, because they never actually taught what the course catalog or curriculum said they were going to teach, which is a terrible argument, and it was a stretch on my part, and the judge knew that, and he kind of looked at me and went, what else you got? I said, fine, if it's not a breach of contract, then it's a negligent hiring and retention case, which is a tort, is a real thing. The students are suing the school for negligently hiring somebody who didn't know what they were doing, could not teach, wasn't qualified to teach these courses, and their negligence in hiring and retaining this employee and failing to properly oversee or instruct this employee caused damages to my clients because now they can't obtain jobs, and they lost all this money that they paid out in tuition and stuff. And the judge went, that's thin. I mean, you're going to have to prove that the school did in fact have some negligence on their part, that they had a duty to bring somebody in who had a certain level of skill and experience or whatever. And so, long story short, the judge kind of went, you're on very shaky ground. But what ended up happening is he let the case continue based on the breach of contract claim. And as the motion hearing was over, and he ruled in my favor to allow the case to continue based on a theory of breach of contract, he said, now, Mr. McBride, you're going to have to prove that contract exists. And that was the judge's way of saying, now, don't celebrate. You're in deep trouble here, because that's a hard contract to try and prove. And I know we haven't gotten into it, but without being able to say that the school had a contractual obligation to give them a certain level of skill and technique in massage therapy, that has to be part of the contract. Otherwise, there's no breach of contract claim. And it's hard to do that without turning it into an educational malpractice claim. So what do you do at that point if you're a trial lawyer and the judge basically told you, I'm letting your case continue, but warning, you're not going down any really easy roads. The attorney for the other side eventually called me up and to say, well, that didn't go too well for you. And I, of course, trying to be as confident and, knowing that it's all part of the game and part of negotiation, I said, well, I won that hearing, as a matter of fact. I think things are going quite well. But in the back of my mind, I'm thinking, how in the world am I going to try to prosecute this as a breach of contract case without saying that they had an obligation to teach them teach them better, to turn it into a malpractice kind of argument. So, in the back of my mind, I really wanted to settle that case. So, but that's the importance of cause of action. The law only recognizes certain opportunities for recovery. The facts of your case have to be recoverable. They have to produce a set of circumstances for which the law recognizes a recovery. And I think that's probably the best way to. So, that's what a cause of action is. A set of facts for which the law recognizes a right to recover, if they occur. So, for each of these torts that we're going to talk about, each one of these torts that we're going to talk about is going to be a cause of action. And what the plaintiff has to do in order to recover, in order to get those damages, that money that they're seeking, as a result of being subject to a tort, is they're going to have to prove that that set of facts that makes up a cause of action exists. They have to prove certain facts happened and occurred in order to get their recovery. So the way that we study these is we break them down into elements. What does the plaintiff have to prove to show that they're entitled to a recovery? That they win, basically, if we're going to put it in more plain terms. What do they have to show in order to win? And we call these elements. All right, so for a lot of these torts, we're going to break them down into elements. And that, I think, is probably the easiest way to study it, is to look at the essential elements of each one of these torts and learn them. And also, you get to see, we talked about IRAC and applying facts to the rules. We get to see a lot of the gray areas by playing around with the individual elements. All right, so we're going to do some of that in here, and the torts law is an excellent area of law for learning how to IRAC and learning how to play around with some of those gray areas. So what we have is how we organize this as well. I mean, torts is a series of causes of action. We organize these causes of actions into 3 broader categories. And not to ruin the surprise, but these categories are based on state of intent, mindset, frame of mind in committing whatever the action is. So we have intentional torts, where the state of mind is going to be with intent. Somebody acting with intent, intentionally doing something that causes the loss that we're talking about. Negligence, which we talked about a little bit earlier, but basically negligence is just another way of saying either being careless or being stupid. So again, difference between intentional torts and negligence. Intentional torts, you intend to do something. Negligence, you didn't mean it, but you weren't careful enough, or you were just being dumb, and that's why it's your fault. And lastly, strict liability, which is sort of the really strange one. This one, there is no frame of mind, no state of mind necessary. Strict liability means if you're engaged in a certain type of behavior, a certain type of activity, and someone gets hurt, it doesn't matter how careful you are, it doesn't matter how much precaution you took, it doesn't matter anything. If you're doing certain things, someone gets hurt, you're liable, period, end of story. So strict liability is just as strict, I mean, not to overuse the term, but as it sounds. Strict liability is a very serious thing. Well, we'll talk about all 3 of these. So let's start with intentional torts. All right, again, the critical part of intentional torts is that we're talking about something where the state of mind is to be acting with intent. And each one of these torts, we're going to talk about some of them specifically. Your book goes into a lot more of them than we're going to talk about here. Because I just want to give you a handful of them so that you can understand the concept of elements and playing with them and applying them and that sort of thing. But we're going to, for all these torts, we're going to have 2 major elements. First of them being intent. For all of these intentional torts, intent is going to be required. That's why they're called intentional torts. And secondly, some act. And the important thing to remember is that we're going to marry those 2 things together. It's not just any kind of intent. And it's not intent to commit a certain harm. It's intent to do the act that intentional tort requires. All right? And by act, we mean some voluntary movement by the defendant. So a failure to act is not an intentional tort. It might be something else. But you always have to have some affirmative movement or some action taken with intent in order for it to be an intentional tort. And this will come play out a little bit as we get into some of these. You'll see what I mean. Damages, and in this context we mean damages in terms of something actually being harmed or lost. With intentional torts, damages are never going to be part of the elements because it's not something where we're looking at somebody has to be injured in order for it to be a recovery. Right? And we're going to talk about something like false imprisonment as an intentional tort, and your book talks about that too. With false imprisonment, if you are locked in a room and you're stuck there for, 4 hours, and then you're let out, do you have a broken arm? Do you have a busted limb? Somebody smash your car? Did your house burn to the ground? No. Ultimately, there are no real damages or loss other than inconvenience or time. You might have been late for something, maybe some stress, some being frightened, about being locked in a room and not knowing what's going to happen to you or something like that. But for the most part, there's no tangible loss like there would be if someone punched you in the face or someone was driving down the road and smashed into your car. So in many of these cases, we're going to talk about assault too, where the harm that's caused in an assault is just the causing of fear for even just a split second or just a moment. So we don't focus on the actual harm or loss in intentional torts. From a practical standpoint, the reason why we don't is because when somebody does something with intent, and an intent to commit these acts that we're talking about, usually the law will allow for punitive damages to apply. So for example, if you sue somebody for the intentional tort of assault because they threatened to hit you over the head with a baseball bat, and you're able to prove the elements of an assault, the actual damages that you should be compensated for are probably very minimal. Usually in cases like that, the jury will find in favor of the plaintiff and award what's called nominal damages, and that's usually $1. So what's the point of bringing the lawsuit? Because you can ask for punitive damages if somebody really did commit an assault and intend to do something that would cause you fear. And for that state of mind, for being that messed up, the jury may award punitive damages against the defendant. And that's a dangerous, dangerous thing, because those are almost, I won't say that they're unlimited, because they are limited in some cases, but that's the real potential recovery for an intentional tort case. So don't focus on damages as being required in order for it to be an intentional tort. Even if somebody doesn't suffer any actual harm, that doesn't necessarily mean it's not an intentional tort. Focus on your essential elements, and that's how you'll find out whether a tort was committed. Alright, so let's talk about some of these. The first of these causes of action we're going to talk about is battery. Now, I know there's some students that have criminal justice backgrounds. Battery is also a crime. I don't actually know off the top of my head. Actually, I think in Maine, battery is no longer a crime. It's just different levels of assault, different degrees of assault. So, but whatever. It sounds like a crime. It also sounds like a Duracell, but we're not talking about either one of those things. Battery in this case, we're going to talk about it in terms of being an intentional tort. All right, and these are the elements for an intentional tort. And one other thing on that, I'm sorry, before I go on. When writing an exam about this, in civil law, we don't say that someone's guilty of battery. We say that someone's liable for battery. All right? That's another difference between civil law and criminal law. People aren't guilty in civil law. They're guilty in criminal law. And liable in civil law. All right. So, just don't get them confused. So here are the elements for battery. And again, these are what the things you have to prove in order to prevail in a claim against the defendant for battery. First, no surprise. We need to have intent. Someone needs to have done something intentionally. And the act that they need to cause is a harmful or offensive contact. And then there's one other additional element, which I guess could be combined with the second one, but I like to split it up just to make it a little easier. And it needs to be harmful or offensive contact to a plaintiff's person. Now, let's play around with these a little bit. All right? For example, when we're talking about intentional, harmful, or offensive contact, your garden variety battery is going to be punching somebody in the face. And I cannot tell you how much I absolutely love that picture. It's really priceless. So that's your garden variety battery. I see you, I intend to hit you in the face because I'm upset about something or whatever, and I cock my arm back and I do it, and you get that result. That is a battery. There's another case, though, that I really like to talk about with students. There was and this is some image from an old Hollywood movie, so this is not representative of the case, but same kind of idea. So there was one of these kind of like morning radio shock jock types who, you know, likes to kind of spit in the face of society just for good ratings on the radio. And he had this brilliant idea to bring in a really strong opinioned feminist, and he was just going to mock her and sort of embarrass her on the course of his morning show. And one of the things he did in his studios, he brought in, I don't know if it was cigars or cigarettes, whatever, but spent most of the interview just blowing smoke directly into this lady's face. And so she ended up suing him for the intentional tort of battery. And so if we go back a little bit here now, in order to prove that, she's got to show intentional, harmful, offensive contact to her person. So, did he act with intent? He did. He intended to blow smoke directly in her face. Was it a harmful or offensive contact? Well, it was clearly offensive. I mean, cigarette or cigar smoke or whatever can certainly be offensive to somebody. Harmful, I suppose, but again, we're not looking for damages, so you don't even need to go to the point of causing secondary inhalation of smoke and cancer and all that stuff. You don't even need to go there. Is it harmful or offensive? And that's clearly yes, and it was to her person. The question that he raised to try to defend himself in this lawsuit is one of contact. Like, I never touched her. I mean, look at this picture here. I mean, there's smoke there. And long story short is that the plaintiff won in that case, and she won by arguing that smoke is made up of tiny particles of matter. It's not something invisible. So there was contact with her person, and that was the court's ruling, so she prevailed on that. On the other hand, there have been cases brought where somebody, and I think there's a classic Sopranos episode where the Tony Soprano and some of the other guys are all mad at somebody who did something to cheat him out of some money or something, and in order to get back at them, they park their boat on the right off the shore from where this person's house is, right on the water, and they set up these enormous speakers and blast Dean Martin music at this guy's house at extremely high volumes, like 24 hours a day for like a week. And there are other cases like that as well, where it's a battery case. So again, we're talking about intentional, harmful, offensive contact to a person, but the contact in question is sound and sound waves. And those plaintiffs, in those cases, the sound wave cases, or the vibration cases, like somebody who sets off an explosion over, and the vibration of the ground causes somebody to fall down or something, those people lose their cases because they lack contact. So this goes back to the Iraq thing. Remember the example I gave in the Iraq about the apple. The analysis you can do there, depending on your facts, if you miss the contact question, the sub-issue of contact in these battery cases, you would not have done a completely thorough Iraq of these issues. So you can really get into some kind of weird gray areas. All right. Another place that we can get into kind of a gray area in this is with intentional. So imagine this. I'm standing in a bar, and I see my hated nemesis on the other side of the room. So I pull out my gun, I aim it, and I fire. But you know what? I'm a terrible shot. So I don't hit that person, I hit you. And of course that's a harmful or offensive contact, and it's to your person. But my argument is going to be, right, but I didn't intend to hit you. I intended to hit that guy, and I missed. So how can this be an intentional tort? I mean, maybe it can be negligence, because you could say I'm putting you in an unreasonable risk of harm by firing a gun in a public place, and I breached that duty, and that duty caused you damages, clearly. But if we're looking at it from an intentional tort standpoint, is there a case for battery? And it's all going to come down to that first element, intent. Did I have intent? And the argument on the plaintiff's side to say that there's no intent is to say I didn't intend the act, harmful or offensive contact. And that's wrong. Don't get caught up in the damages question, the harm question. I did intend harmful or offensive contact. I just didn't intend the harm or the damages that occurred from my action. So that's called transferred intent. If I intended harm over here, but I ultimately caused harm over there with the same act, that same whatever it is, then the intent can be transferred from one person to the other. Alright, so that's another kind of way you can play around with this. And I'll give you one last one, that way that battery can become sort of sticky from an analysis standpoint. Let's say you and I are walking down the street next to each other, and we're not like enemies or anything, now we're friends, and I just throw my arms up in the air and say, gosh, it's just a beautiful day, and accidentally I hit you in the face, and you fall over the curb, stumble down, trip on a sewer grating, fall into the street, and get run over by a bus. So, you want to sue for battery. Intentional, harmful, offensive contact to your person. Now, I did move my arm intentionally, right? Did I intend the act, harmful or offensive contact? And don't get caught up on whether or not I thought or knew or suspected that maybe you'd get hit by a bus. That's the damages question. The question is, did I intend the act, a harmful or offensive contact? And the answer in that case is no. I didn't intend a harmful or offensive contact. The argument from the defendant's standpoint is that you did intentionally swing your arm around. Alright? But that's not the same as actually intending a harmful or offensive contact. Let's change the scenario a little bit. This time we're walking down the street, and we're good friends, and we're laughing and joking around, and you make a joke about me, and I playfully reach over and just kind of shove you on the shoulder a little bit. Well, that causes you to stumble, you trip off the curb, trip off a sewer grate, and end up in the road and get hit by a bus. Totally different scenario now. Don't get caught up on the bus, right? That's the damages question at the end. The question is, did I intend a harmful or offensive contact? And that little playful shove on the shoulder is enough to be a harmful or offensive contact that would, to your person, that would make me liable to you for battery. I don't have to intend the actual damages that occur at the end. I never intended for you to get hit by a bus. It's not like I said, oh, here comes a bus, I'm going to throw you out in the street. I just intended that harmful or offensive contact. Alright? So that's a little bit on battery. But again, your garden variety one is our guy up there on the left side getting punched in the face. So let's talk about the next one. Assault. We've got elements for this one as well. First, intent, again, to cause reasonable apprehension. So instead of a harmful or offensive contact, this time we're causing reasonable apprehension or fear. It's another way of saying fear, apprehension, of immediate harmful or offensive contact. So the battery kind of plays in at the end. Its intent to put somebody in fear that they're about to be subject to a battery is another way of saying this. Alright? So, a lot to play with in this one as well, especially the question of reasonable apprehension. Alright? And the idea of being immediate harmful or offensive contact. So if I say, tomorrow at noon, I am going to punch you in the face, and I try to put you in fear of that, that's not immediate harmful or offensive contact. It needs to be right now, right here, and I have the ability to do it right now. And even if you're holding up a gun that is not loaded, trying to put somebody in fear that they're going to be shot by holding up a gun that wasn't loaded is still an assault. You can't say, well, I didn't have the ability to actually shoot the person because the gun's not loaded. It's still an assault. You're causing fear that they're about to be shot, and being shot is an immediate harmful or offensive contact. So that's still an assault. Reasonable apprehension. Now, I don't know how many people watch MMA, but there's a guy in MMA named Rampage Jackson who's enormous. And if I saw him on the street and I went up to him and stood right in his face and cocked my hand back like I was going to punch him in the face, in reality, he would either A, laugh at me, or B, absolutely dismantle me into a million pieces in about 4 seconds. But let's say I do that. Can I cause somebody like that, who's so much bigger than me and has absolutely no reason to fear any contact from me? Can I put that person in reasonable apprehension? And the answer is yes. All right? Don't get caught up on the, well, you're not really going to hurt this person anyway. Is it reasonable? It's not the apprehension has to be reasonable. So, you can't, if I walk up to you and say, hey, how's it going? And you say, oh my God, and cower in fear, you can't say that you were reasonably fearful of something. But if it's a punch we're talking about, it doesn't matter that the person threatening to throw the punch, it doesn't matter that the punch is something that can cause a fear or apprehension. So it can mean awareness of it. So somebody who's a weakling, like yours truly, can assault somebody who's a giant. All right. Reasonable is stretched in this case. We're going to use the term reasonable a lot when we talk about torts, and we're going to use it actually in a couple other contexts as well in this course. But in this case, it means, pretty much not delusional. Especially when I'm testing you on this, I'm not really going to try to put this in a really gray area and make it really difficult for you to figure out whether or not that person's being reasonable. If the person's not being completely delusional and crazy, like, oh, hi, how are you? And then they're in fear, then you can pretty much assume that it's reasonable apprehension. All right, so what are we talking about here? I mean, this is your garden variety classic. I mean, look at the guy's face. He believes he's about to be punched right in the face. And the other guy, look at him. He is clearly, queuing that fist up to make contact with him. This is an assault right here in this picture. I can't possibly explain it any better than that. One person is about to do it. The other person is clearly in a reasonable apprehension that they are about to be subject to a battery immediately right now. All right? So the threat has to be immediate, and words alone are not enough. So if that guy didn't have his fist up and he was just standing there saying, I'm going to punch you in the face right now, that's not enough. You got to look for some action, some raising the gun, cocking the hand back, something like that in order for it to be an assault. Okay, false imprisonment. This is another fun one. We have 3 elements to this one as well. All right, intent. Again, this is going to be the first element to all of these. You have to do something with intent, and the act that we're talking about in this case is a confinement or restrainment. So it's intent to confine or restrain to a bounded area. Now, confine or restrain is pretty, I think that's kind of self-explanatory. I mean, if we really wanted to, we can play with that one a little bit, but I'd really rather not. I'm more concerned with the third one. All right, so if you have somebody, you literally have to have somebody who's stuck between 4 walls with no exit. All right, I'll give you an example. One of my favorite cases that we don't actually read in this course, but someday I might start assigning it if it's not too long. It's called Hardy versus LaBelle's, and LaBelle's is was, I don't think they're open anymore, but LaBelle's is a chain of department store chain down in the South. So Ms. Hardy was an employee of LaBelle's, and she was a relatively new employee. And she was there doing her thing, working on the sales floor, stocking, merchandise and whatever on the department store floor. And one of the other employees went to a manager and said, hey, that new employee over there, she's stealing merchandise right off of the floor. And the manager said, really? Okay, thank you for telling me. So the manager goes and takes her aside and says, hey, how rude of me. I haven't given you the tour. Come with me and I'll show you around. So he takes her around and says, oh, this is the area where the offices are, and this is the bathrooms, and this is where the break room is. So by the way, why don't you have a seat here in the break room and I'll be right back. And she says, okay. So she sits down in the break room. He leaves. And then in a couple minutes, who walks in the door but the store security and loss management professionals, along with a police officer. And they begin to question her about stealing merchandise off the floor. And she says, no, I didn't steal anything. What are you talking about? No. And she continues to deny. And finally, After a while, the police and the loss prevention guy, they say, well, can we search you? And she says, am I under arrest? I don't understand. But eventually they figure out that she didn't actually steal anything, that some employee thought she stole something, and she's actually perfectly clean. So she is let out, she quits because she doesn't like the way she's been treated, and she sues them for false imprisonment. Now, here's what this case came down to. They talked to the store manager, and they put him on the stand on the trial, and they said, Mr. Store Manager, what did you do? Take us through that day. Well, I took her, down the hall. I showed her a couple things. I told her it was a tour, and they asked, so she didn't know that she was being pulled aside for questioning about stealing stuff. And he said, no, I told her it was a tour, and then I put her in the break room and said, okay, stay right here. And then the lawyer asked, did you lock the door? Did you lock her into the break room? And the answer was no, I left the door open. And they said, okay. The door was unlocked, but closed. So then the police and the security people came in, and the question was the door locked while you were questioning her? And they said, no, the door was unlocked. And so then they put Miss Hardy on the stand and said, why didn't you get up and leave? And she said, I couldn't get up and leave. They were questioning me, and if I got up and left, I'd look guilty. So I had to stay there and answer their questions to prove my innocence. That's why I was falsely imprisoned. I was confined and restrained to a bounded area by the circumstances, not necessarily by a locked door. And I love talking about this in class when we can kind of bat the idea back and forth, whether or not this constitutes false imprisonment, because I think those are pretty strong arguments on both sides. I mean, a reasonable person who's been wrongly accused of stealing something is going to stand there, or sit there in this case, and answer the questions and say, I didn't take anything. And yes, they're going to be upset, and they're probably going to quit their job, but they're going to defend themselves, and they're going to say, I'm perfectly clear of this, and I'm willing to prove it. So she did necessarily the right thing, but does she have a cause of action for false imprisonment? And the answer in that case was no, because it wasn't a bounded area. The court found that because the door was unlocked, and technically she could have got up and left because she wasn't under arrest or anything like that, that she wasn't confined to a bounded area. So kind of a sticky situation, but that's how strict the idea of a bounded area is. I also don't want you to get confused. I mean, when you're imprisoned for a crime and then later on found not guilty of that crime, that's not a false imprisonment. All right? Because there's an element of being wrongfully confined or restrained in here too, and the state, especially, it's not a false imprisonment because the state is going to have an immunity to a suit for that, because that's their obligation in criminal cases, is to find someone who they have reasonable suspicion or probable cause to arrest for a crime, and to hold them until the criminal justice system can find them either guilty or not guilty. So what are we talking about in false imprisonment? I mean, garden variety, someone who's stuck in a room. I mean, if Ms. Hardy was doing this and couldn't get that door open, totally different case. But that's the kind of thing we're talking about. Beware of the I'm just in your way and won't let you go the way you want to go scenario. It has to be 4 walls, 4 bounded walls. So there's been cases like that before where somebody cornered someone else by kind of blocking them in a hallway and saying, no, you can't get past me until you answer this question. I won't let you pass. And the answer is, if you can turn around and walk the other way, you're not imprisoned. So think of the guy over here in this box. I mean, you need to be confined between 4 walls on all sides with no means of escape. All right, that's a false imprisonment. All right, so those are 3 sort of really playful kind of intentional torts. Your book goes into a bunch more of them, and they categorize intentional torts can be. They don't do this, but they should have. This is another problem I have with your book, is the way they've organized this. But really there are 3 different types of intentional torts, and although we didn't get to talk about a lot of these, I'm just going to kind of throw them at you. We talked about battery assault and false imprisonment, and there's also intentional infliction of emotional distress, which kind of drives people insane, because they say, how can infliction of emotional distress, oh, you feel sad, so now you have to pay for it. Well, one quick thing about intentional infliction of emotional distress. The standard for proving that the defendant's conduct rose to the level of needing to be liable for this is extremely high. Let me give you an example of what I mean. In order for intentional infliction of emotional distress to be proven, right, part of the elements of an intentional infliction of emotional distress is that the defendant engaged in conduct that can be considered outrageous, and that's the exact word. And then the funny part about that is that when cases were prosecuted asking the courts to explain what that means, what it means for conduct to be outrageous, the only response, well, not the only response, but the best response that I've read on that is where a judge said, well, it would cause the average member of society to stand up from their chair and say, that's outrageous! So, that's the standard for how off the wall the conduct needs to be. An example of an intentional infliction of emotional distress case is, for example, where somebody has taken advantage of a sensitivity or mental, or kind of like a phobia or some other kind of mental fear that they know the person has. So in other words, if you know somebody who's deathly afraid of spiders, and you dump a dump truck full of spiders into their house while they're at work just to see what will happen when they get home, and of course it causes them to go into a severe emotional state and causes them emotional distress, well, your conduct is pretty outrageous. You did that on purpose just to mess with somebody, and you knew what their sensitive point was, and you pushed it as hard as you could. That would be an intentional infliction of emotional distress. So it's not necessarily the case where it's like, you got mad at me and, because I didn't give you the grade you wanted on your test, and now you're emotionally distressed and you can sue me and say, you caused me intentionally emotional distress. Well, my conduct's not going to be outrageous in that case, right? So I know that there's sort of a societal bias against the emotional distress tort claims, and for good reason, because some of them are brought pretty frivolously. But in order for somebody to really prevail on this, it has to be a much, much higher level of conduct than, and it needs to be intentional as well. Remember, we're talking about intentional torts. So there is a lot of value for having this as a cause of action. Invasion of privacy is another one. It's an intentional, it could be something like literally putting a hidden camera in somebody's room to spy on them. It could also be something like utilizing somebody's private, an image of them that's private for commercial gain or commercial use, like using somebody's image without their permission and making it look like they're a sponsor or a user of your product. If you catch a picture of Brad Pitt walking down the street drinking a Starbucks coffee, and then Starbucks all of a sudden, well, that wouldn't count. Let's say you did it at home. You snapped a picture of him, he's out on his yacht. He has an expectation of privacy there, and you snap a picture of him sipping a Starbucks coffee and you use it as the flagship image for a marketing campaign. Well, that's going to be an invasion of his privacy. So some of that stuff too could fall into that. And lastly, one that I think we all know about, defamation. Defamation comes in 2 flavors, libel and slander. One of them's written, one of them's not. And the idea there is that somebody's saying something about you that's not true. Truth is a defense for defamation. So, for example, I know your book mentions the Roger Clemens, Roger McNamee, I think his name's Brian McNamee, or whatever his trainer's name was, who had gone in front of Congress and said that he had seen Roger Clemens using steroids. Roger Clemens said that he didn't, and then sued McNamee for slander, saying that he was lying. And McNamee's defense in that case was, I told the truth, which is always a defense for defamation cases. And I actually don't know how that turned out. I don't remember, but I know it is in your book, and they talk about that case. And maybe they don't say how that one works out anyway. But those cases can be extremely dramatic because you can have, in the courtroom, I mean, like literally a lot of drama in the courtroom, because you might have somebody who's made some outrageous claim that's offensive and inflammatory, and the defense of that is, well, I told the truth. You know, if you're going to talk around town saying that so-and-so is an axe murderer, and they're going to say that's a lie and you're defaming my character, and then you go in and say, well, it's true, you are an axe murderer, well, now all of a sudden you have to prove that they are, and that can lead to some pretty drama-laden stuff in the courtroom. So, really fun. Lots and lots of fun from the lawyer's standpoint. Also, make a great plot for a Hollywood picture. Copyrighted, nobody steal it, it's mine, I called it. Torts against business. Businesses can be subject of a tort. Wrongful interference with a contract. So, interfering with a contractual relationship, causing one party to break a contractual relationship with somebody else, can be a tort. And this has come up a couple times. It's a kind of rare and kind of odd situation, but that's possible. And product disparagement, which is basically defamation, but instead of being defamation of an individual's character, it's defamation of a business's product. And again, truth is going to be a defense to that. So, if you're going to say that, go out in the market and say, you know, I work for Dell, and I'm going to go out in the market and say that Apple computers will set your house on fire, you better be able to prove that there's some defect in Apple computers that will actually cause the product to burst into flames. If you're lying about that, product disparagement is the tort that you could be staring at. And lastly, torts against property and trespass to land being the most obvious one. You've intentionally crossed on to somebody else's property. May also be a crime, but for the most part, even if you're not there to burglarize the home, but just crossing onto their property can be considered an intentional tort. Conversion is a little bit more serious than that, and usually we're not talking about real estate or property. We're talking about personal property, things, stuff. And conversion means you've either taken it over completely so that the other person cannot possibly have it or use it or get any utility from it, or you've completely destroyed it so that that person has no use or ability to a value from it. And the diet conversion thing is called trespass to chattel, and that means, yeah, you didn't take away 100% of their value and utility of their personal property, but you've damaged it significantly. So conversion would be, I stole your car and drove it into the ocean. Trespass to chattel would be, I keyed your car and put a big scratch down the side. All right, both of those being intentional torts, just slightly different. And of course, we don't focus on the damages, right? They're different. They each have their own tort, but obviously, the degree of recovery is going to be slightly different, and punitive damage might apply. All right, so that's intentional torts in a nutshell. And I don't want to go too deep into that. I think you get the flavor for it, and honestly, it's a pretty straightforward part of tort law. So the next category of torts to get into is negligence, and this one is much, much bigger, and we're going to spend a little bit more time with it. All right. The first thing to note, the difference between the mental state between intentional torts and negligence. With intentional torts, obviously, we were talking a lot about people doing things intentionally, intentional acts. Now with negligence, we're not going to talk about intent. We're going to talk about someone doing something because they're careless or because they were acting stupid. All right? And in order to prove negligence, you know, the same thing as intentional torts. When you're proving negligence, there's 4 elements. Oh, before I get there, another difference between negligence and intentional torts is that intentional torts is a category of torts where there are a bunch of different causes of action, right? We just listed them all right here. These are all different causes of action. Battery, assault, false imprisonment, intentional infliction, emotional distress, invasion of privacy, all of this whole list right here, all the way down, everything in red, are all different individual causes of action. When it comes to negligence, there's just negligence. There's different ways to say it. Like I mentioned before when I talked about my my case with the massage therapy students, one of the things that I alleged was a cause of action for negligent retention and hiring. But that's just another way of saying negligence. And that's all it is. And it's the same 4 elements. It's just a different set of facts. So whereas the situations, the causes of action, the factual scenarios in each of those causes of action was extremely specific. I mean, you think about battery versus assault. They are very specific factual situations in order to fit into those causes of action. In negligence, we're talking about one cause of action that is very vague and very broad and very widespread, and many factual scenarios could possibly fall into this. It's meant to be very broad, all right? It's meant to be extremely broad, because when somebody's acting careless or stupid, which you can do in so many different contexts in your life, and there's so many potential ways that you can hurt somebody by acting careless or stupid, you need something like this. So I once read, and I wish I had the source for this because it is an outrageous claim, and of course, you know, the old saying is that, you know, 80% of statistics you hear are made off the top of somebody's head, and I guess this maybe falls into that category as well. But something like 97% of the lawsuits, civil lawsuits that are filed, include some claim, some negligence claim. And I wouldn't repeat that if I didn't believe it. Because negligence is so broad, it's very easy to fit almost any factual scenario where one person has gotten hurt on the end of it into some kind of a negligence claim. All right, so we'll go through this and I think you'll get to see what I mean. Negligence is a single cause of action. It requires, in order to prove it, requires 4 elements, and we're going to go through each of these elements individually and talk about them. Because they're so broad, they're a little bit more difficult to prove than just saying intent, act, you know. Some of these will be quicker than others, but we do need to go through each of these elements individually. The first of them being a duty. Duty is another one of those words we're going to use pretty much constantly through this class. In contracts, we know that the definition of a contract is that it's a mutual, you know what, I'm going to flip through my notes here for a second and read it exactly. Hold on one second here. Okay, a contract is an agreement or set of agreements imposing duties and for which the law recognizes a remedy if those duties or obligations are not met. So again, we talked about this when we talked about cause of action, right? There is such thing as a cause of action, a breach of contract, because the law recognizes a remedy if those duties are not met. We're going to talk about duties again when we get to corporations. We're going to talk about duties again when we get to agency and employment. It's just something that comes up constantly. The important thing to remember when you hear the term duty, not just in negligence and torts, but in all of these things, duty means that one person has to do something or the other person is going to have a lawsuit and they're going to prevail. Duty is an affirmative obligation on one person to do something that if they fail, it's going to lead to liability. All right, so it's a big deal in the law when there's a duty involved. All right, so something not to be ignored. So the first thing we need to have in negligence, we need to have a duty that exists. And not to spoil the surprise, but there are pretty much duties applying to all of us all the time in whatever we're doing. But we'll get to the questions that can be raised and how you can kind of play around with the analysis on that element. The second element is a breach. So there needs to be a duty, and then you need to be able to show that the defendant didn't live up to that duty, that they failed in some aspect. All right. So first you need to know what that a duty applies and what that standard is, and then you need to be able to say that the defendant failed to live up to that standard. Third is causation. So it's hard to kind of explain causation without giving you the fourth element, which is damages. So let me backtrack for a second and talk about causation. You need to be able to connect all of these together, and causation is sort of the glue that holds them, right? You need to have a duty and a breach. You need to be able to show that that breach caused damages, all right? The breach causes the damages. So the cause is what connects the breach to the harm that happened because of the breach. All right, so cause is a little bit hard thing to prove, right? Sometimes it's hard to connect a defendant's action to somebody's injury on the other side. This is where a lot of negligence cases can get really sticky. So the duty question is a tricky one. The breach one is fairly easy. The causation one can be very sticky. And then the last one, damages, is really simple. All right, all you really need is to show that somebody was damaged either in their person or in their property, that they suffered some kind of loss. Note the difference here between negligence and intentional torts. With intentional torts, I told you, don't worry about the harm on the other end. Don't think about it in terms of somebody has to have suffered some kind of an injury. Well, now in negligence, we are very interested in that. We're very concerned, right? Classic example, and we're going to use this example throughout because it's one that I think fits so well and it's so easy to understand. But if I'm driving down the street and I'm not looking at the street because I'm texting or I'm changing the song on my iPod, then I have a duty to the other drivers on the road, to pedestrians that might be out there. I have a duty and I'm breaching it. But if I don't actually hit anybody, is there a cause of action for negligence against me? And the answer is no, because there's no damages. Nobody has any damages against me. So if you see me driving down the street and you see that I'm not looking at the road, you might look at me and go, oh my God, that guy's being incredibly careless and or stupid. And I remember from my business law class that means negligence. But if I don't hit you or hit your car, then you don't have a cause of action against me for negligence because you don't have any damages. So this time the plaintiff has to prove that because of that breach, they actually lost something or something was actually harmed. All right? So that's a big difference between negligence and intentional torts. So we're going to go through each of these individually. All right? We're going to start with duty. And again, this is, there's only two sticky ones in here, so this is going to be one of them. What I mean by duty is that there's a legally imposed standard of care or conduct, and it's imposed in order to protect others from an unreasonable risk of harm. So the idea of an unreasonable risk of harm is an important concept, and we're going to talk about that too. But let's start at the beginning. The idea that there's a standard of care imposed. All right, two important questions to answer when it comes to duty, and I kind of alluded to this before. First of all, to whom are duties owed? All right, and second, what standard of care is going to apply? So the first thing you need to figure out is the person who got injured, are they owed a duty from this defendant? And secondly, if so, what standard of care? So let's talk about those two questions. Let's take them individually. First of all, to whom are duties owed? All right, we answered this question a little bit talking about another case, and that case is Love versus Morehouse College. Now, I hate this case because it makes me sad. It's unviolent and it's hateful. It involves an actual hate crime, so I don't really like talking about it. But unfortunately, it's an excellent illustration of how kind of sticky this can get. And just to recap the facts of this case, it was two students at a university, and one student thought, or at least had the perception, that the other one was a homosexual and had looked at him in some inappropriate way. And so he beat that student very violently and horribly. And the student who was beaten sued the university. Now, this runs contrary to what you might think would happen, because the person who directly was responsible for his injuries is obviously the student who beat him. But two reasons. Number one, well, the primary reason is if you're looking for someone to sue, attorneys are going to look for the pocket that's the deepest. And what good are the pockets of another college student? Not particularly deep. But the university, a private university, by the way, not a public one, a little bit deeper. So that's where the attorneys went. However, the question of do they owe a duty to this student in this case? Now, colleges absolutely owe duties to the students. There's no question about that. But remember that the duty has to be sort of linked, to what's going on. So, I think I made the comment in class that I owe each and every one of the students sitting in the class a duty at that moment. As a matter of fact, the students, you owe them to each other. to not put each other at an unreasonable risk of harm. But in certain contexts, you might not owe them a duty. So, duties are owed to foreseeable plaintiffs. All right? And the question of foreseeability in this case became the linchpin. So, the student filed his lawsuit against the university, and the university responded and said, we didn't owe a duty in this case to protect him from violent crimes because it was not foreseeable that he would be subject to a violent crime. It's unfortunate that it happened. We're very sorry about it, but it wasn't foreseeable on our part. How could we possibly have known that this other student was going to do that? And the student's response was, it was foreseeable that there could be a violent act taken against a student who either was or was perceived to be homosexual because of the culture of violence and the culture of hatred that had been fostered on the campus towards those students. And they presented in their lawsuit a number of facts suggesting that in the past there had been situations that had been kind of swept under the rug, not addressed properly, that there had been warnings or complaints or threats that had been brought to the administration's attention that they had ignored, and they had done so because they had no interest in addressing the issue on campus, therefore kind of fostering this environment of not being willing to protect those students. Now, I don't want you to get the wrong impression. This case never progressed. Well, eventually it did, but at the time this opinion was written, it never progressed past the pleading stage. So here's what I mean by that, and I got to get into a little bit of civil litigation to explain, or civil procedure, I should say, to explain, so bear with me for just a second. But when you file a lawsuit, what you actually file is something called a complaint, and your complaint is going to list all of your causes of action and the factual situations, the facts that support the elements for that cause of action. So if you're filing a lawsuit in negligence is one of your causes of action, you're going to have to plead facts to show that there's a duty. And how do you do that? Well, number one, you plead facts to suggest that you're a foreseeable plaintiff, to show that you're owed a duty. All right. So in this case, and the plaintiff's attorney in this case at Love versus Morehouse College did that, and these were the facts that he alleged in the complaint, that there was this culture of hatred and sort of an attitude at the administration that they didn't want to deal with it and weren't going to. But that doesn't necessarily mean that they're true. As the lawsuit progresses beyond the pleading stage and after you filed your lawsuit, by the way, after you file the complaint, the defendant's going to file what's called an answer, in which they're going to either admit that what you've alleged is true, line by line, or they're going to deny it. And I can guarantee, as sure as you and I were all born, that when it got to that section about them fostering an environment of hatred, they would deny that that's the truth. But we never got to that, because instead of filing an answer, they filed their motion to dismiss, saying even if everything in here, let's assume it's all true, 100%, the plaintiff cannot possibly win on negligence because he's still not a foreseeable plaintiff. So of course the judge had to look at what's in the pleadings, at what's in the complaint, and say, okay, let's assume it is true. So even though we're talking about Morehouse College as, having this sort of an atmosphere, it's not necessarily the truth. The court is just assuming that it's the truth in this case, because we have to do that to see whether or not the pleading, if the plaintiff was able to prove every single allegation that's in there as being 100% true, would they win? All right, so long story short, Gregory Love won that part of it and was allowed to continue, but it was a lot like, in my opinion, my reading of that case, and I love talking about this with students live in the classroom, my reading of that case is very similar to what the judge did to me when I had that motion hearing for the students that were in the massage therapy class. He kind of looked over at Gregory Love and said, now you got to go prove all that. So put yourself in the seat of Gregory Love and his attorney. They got to go to the college and go to the administration and say, give me all the information you have in the Dean of Students records concerning complaints made about hatred and violence and threats of violence or other types of situations towards homosexual or perceived homosexual students. And what is the university going to say? They either have that smoking gun sitting there, and they're going to go, let's settle this one. Or they're going to say, no such records exist. There is no such thing as that culture of hatred that you think exists here. So this is where sort of, a lot of the strategy comes into play. Because what happens after a motion like that, and in this case, I wasn't involved with this case, obviously, but I'd be willing to bet what happens in a case like this is that right after a hearing like that, the two attorneys get together and start to negotiate to see if they can settle the case. And I guarantee you the defendant's attorney, the college's attorney, is going to say, you're going on a wild goose chase and there ain't no goose. You're going to find nothing because there are no records at this university about threats or violence or hatred, all this stuff. It's all made up. It's all in your client's head. I'm sorry, but you're wasting your time. And he may be telling the truth, or he may not be telling the truth. Because he may be thinking, if I can get this settled now, the information about how horrible things are on this campus for certain students won't ever come out in the public. But on the plaintiff's side, they're thinking, I'm going to get into your guts, and I'm going to pull out every ugly thing I can find, and you know that I can do it. Because legally I have the right to now, because we're going forward with a lawsuit. So if you want to avoid your client some real embarrassment, let's settle this case. Give my client what he wants, however many millions of dollars or whatever. So that's how the negotiation plays into the actual strategy and technique of litigating a case like that. Now, I don't remember 100% what happened with that case. Every once in a while when I teach this class and I say something like that, somebody gets ambitious and goes and looks it up for themselves. And I know there is another case, and by that I mean written case written by a judge that arose out of this particular lawsuit. So there is some information out there about what happened after this case progressed. But I believe eventually it did get settled, and I do not know the terms of the settlement of that case. So, and usually that's very common. A lot of times those things those settlements are entered into under confidentiality agreements. But anyway, I'm off topic a little bit. The idea here is whether or not the plaintiff is foreseeable. So again, think about me driving down the street, not looking at the street, looking at my iPod or looking at my cell phone. Who are the foreseeable plaintiffs in that situation to whom I owe duties? Pedestrians, other people in other cars, people who own cars that are parked along the side of the street. Any of those potentially are foreseeable plaintiffs, and I owe them all duties. You look at the negligent conduct that's being alleged, in this case driving down the street without looking or fostering an environment of hatred towards certain students, and say, who are the foreseeable plaintiffs, the people who could foreseeably be injured by this? And that's how you figure out who's owed duties. So when you have somebody who's, I'm driving down the street not looking at the road, and I accidentally smash into a person crossing the street, and somebody who's in their house on that street looks out the window and sees this happen, and they're so shocked by it they have a heart attack and die. There's a question of causation there, but do I owe a duty to the person that I hit? Yes. Do I owe a duty to the person who is in their house and who had a heart attack because of me crashing into that person? Who are the foreseeable plaintiffs resulting from my conduct, which is driving down the street without looking? The person crossing the street, not the person in their house. So I would argue I do not owe them a duty. All right, moving on. The second question to ask in this is what standard of care applies. Once you know that you owe that person a duty, the question is how much of a duty. So it depends on the relationship between them, but we have higher standards of care and we have lower standards of care. Sometimes the defendant owes the plaintiff an extremely high standard of care based on their relationship. All right? For example, professionals, and I use medical malpractice as an example. Medical malpractice is what happens when your doctor does something that's negligent, that that doesn't, that messes up in their practice and causes you damages. So it can be as ridiculous, and this is not a made-up story, but you go in for an amputation on your left leg and the doctor accidentally amputates the right leg. All right? That's a malpractice type scenario. There's also a lot of cases where doctors will go in to do a surgery and they leave like a surgical sponge inside the person's body. During the surgery, forget to remove it, sew the person up and consider them done, and then the person has all kinds of health issues and they find out that there's been a surgical sponge sewn in them for 20 years or whatever. Medical malpractice. The standard of care, and I'm not going to test you on the specific standard of care for medical malpractice, so you don't need to like commit this to memory, but just so you know, the standard of care for medical malpractice is fairly high. All right, you have a standard to treat your patient as the average member of your professional community. So doctors are held to a standard beyond just like what the normal person would do in that situation. They're held to a standard applicable to their profession. And when you have a medical malpractice case, as an attorney, one of the hard things you actually have to do is to go out and to talk to a bunch of other members of that medical community and say, what would you do? All right. Case in point, I had a case when I was practicing with a lady who went to the emergency room with severe stomach and abdominal pain and nausea and some other symptoms, and the doctor at the emergency room diagnosed her with basically the equivalent of like an upset stomach or indigestion, and told her to take like Tums and to go home and just get some rest, and that she'd be fine, and avoid spicy foods basically. Well, 2 days later, same symptoms continue to persist, and she goes back, and I believe the doctor did this to her twice, the same doctor. And then a couple days later, her appendix burst, she had appendicitis, her appendix burst, and when your appendix bursts, that's very bad because it can cause your body to be septic, and the infections spread throughout your body, and that can kill you pretty quickly. Luckily for her, it didn't kill her. She was able to go into the hospital. She had to have a lot of medical treatment. She was in there for a long time, but they were able to clean the sepsis from her system, and she survived. And she wanted to sue the emergency room doctors for medical malpractice for failing to diagnose appendicitis and instead diagnosing her with indigestion. And as someone who's had appendicitis and who has indigestion pretty frequently, as a matter of fact, including right now, I can tell you that there is a little bit of similarity, but the idea that there's extreme pain at a certain part of your lower abdomen should be a pretty huge indication that there's a possible appendicitis. And how serious those can be if they burst should, at least I thought, give a doctor cause to think, you know what, I better at least check for that. But these doctors didn't. So, and by the way, indigestion is a symptom of appendicitis. It actually upsets and irritates your whole digestive system. So you can feel like that, nausea and kind of like general upsetness and kind of, not right in your, rumblies in the tummy, if you will. So we had to go out as part of this and start talking to a bunch of ER doctors. Now, we couldn't talk to gastroenterologists who are specialists in the gastrointestinal system, and we couldn't go out and talk to people who were other experts in appendicitis, like surgeons who are trained to recognize that and trained to remove appendices. I don't know, appendices, appendice. I don't know how to say that, but we couldn't talk to them. We had to talk to the members of the defendant's professional community and go out and figure what is the average opinion. What would the average member of the professional community have done? Would they have seen the symptoms of appendicitis and have checked for it, or would all of them have been sort of duped in this situation and sent her along? So that's a very high standard of care, especially, but I think it's appropriate for doctors to be held to that higher standard. But let's talk about another one, invitees. You're an invitee when you go someplace go to someone else's property to conduct business for their benefit. So classic example, you go to the mall down in South Portland. You're a business invitee on that property. And for business invitees, they have a very high duty, a very high standard of care to protect you from harm. They basically have to do everything short of wrap you in bubble wrap and make sure that you don't get hurt there. They have to fix or warn of any potential hazards. So that's why if you're ever at the mall, you'll always see caution wet floor signs and all kinds of stuff like that. All right? So those are very high standards of care, way beyond just average. Lower standards, the absolute opposite of the business invitee, is called the unknown trespasser. So if you are trespassing on somebody's property and the owner of that property, or I should say the occupier, because it could be an owner or a tenant, has no knowledge that you're there and has no reason to know that you're there, and you get hurt on their property, and you want to sue them for negligence. Let's say you fall into a hole, something like that. The standard of care is extremely low. So if you're a plaintiff, it's extremely hard to say that the defendant, in that case, the occupier of the property, breached a standard of care to you. They have an obligation to basically fix or warn only man-made, hidden death traps. So it needs to be, number one, something man-made, not naturally occurring. Number two, it needs to be something that's hidden and not obvious. And number three, it needs to be something so incredibly dangerous that it can be classified as like a death trap. All right? So think of it, if you have a minefield on your property, then you need to warn. You need to put up signs, danger, minefield. But short of that, just having a big hole on your property, especially naturally occurring, like a sinkhole, somebody falls into it and they're an unknown trespasser, you have no liability as a property owner. That's how low the standard of care is for unknown trespassers. So that's some examples of some different standards of care. I'm not going to, like I said, I'm not going to test you on, a bunch of different standards of care. There are hundreds of them. I just want you to know that it fluctuates based on the relationship between the plaintiff and the defendant. Here's one I do want you to know, however. In all situations, there is this generally applicable standard of care. So pretty much call this the catch-all. If you don't have one of those special relationships that invokes a higher or lower standard of care, this one is the one that applies. And this is really the only one that I care about you knowing, and the only one that I really care to try to test you on. All right, it's called the duty of reasonable care. And here's that word again, reasonable. The duty of reasonable care says we all have the duty to act as the reasonable person in the same or similar circumstances. So, this is the duty that applies when we are driving our cars. We know that in those situations we owe duties to foreseeable plaintiffs. So it can be, other drivers on the road, people walking down the street, all that kind of stuff. You have the duty to act as the reasonable person in the same or similar circumstances. So, me just looking down at my iPod because I want to change the song that I'm listening to is not what the reasonable person would do in the same or similar circumstances. And this reasonable person is really a fiction. There's no reasonable person out there. Alright? But that's the standard. And ultimately, when we get to the next element, we talk about breach, we're going to see that really it's up to a jury. It's a factual question of whether or not you did what the reasonable person in the same or similar circumstances would have done. But sometimes it's a little more cut and dry than others. So let's talk about breach, and we're gonna ignore the other standards of care for now and just talk about breaching a duty of reasonable care. All right. Did the defendant live up to the duty imposed? So you've got reasonable care. The question we're asking here is, did they act as the reasonable person in the same or similar circumstances? All right, so here's your classic scenario that I keep bringing up. You've got not looking at the road, you've got looking at a cell phone, sending a text message or whatever, and you see that this person is about to hit somebody else. All right, obviously not living up to their standard of care. The reasonable person does not drive down the street and look at their cell phone. So while breach is going to be a question for the jury, I think that's pretty cut and dry. That's one that you don't necessarily see. All right, here's another one. I found this picture and just absolutely love it. Is this But let's assume somebody gets injured, not him. He's likely to injure himself and not the spider, because the spider's clearly in danger. But let's assume that there's somebody on the other side of that wall who gets injured when he pulls this trigger. Duty of reasonable care. Is this person doing what the same or what the reasonable person would do in the same or similar circumstances? No, the reasonable person would never pull out a Glock to try to kill a spider. Alright? That's just not what the reasonable person does in the same or similar circumstances. So these are two that I think are pretty extreme and pretty clear. Let's change it a little bit now. We have here a picture. Actually, this was shot unbelievably by the Google Maps car, the Google Street View car. And what you have is a situation where this bike rider, or I think it's like a motorcycle rider, has had some kind of fall and is now in the street. Now let's assume you're in the car from this point of view and you're facing this and you're about to hit this guy. But instead of doing that, you can't step on the brakes quickly enough and you don't want to hit this poor guy. So instead, you swerve your car as hard as you can to the right and you hit that white car and smash into him, and you avoid the motorcyclist there, but you smash this other person's car over there, and the person in the white car wants to sue you for negligence. Do you owe that person in the white car a duty? And they're going to say that your negligent conduct is not driving in your lane, swerving, maybe driving too fast in order to brake for something like that in front of you. And the answer is yeah, you owe that person a duty. They're a foreseeable plaintiff of your, of your driving the way that you were. But did you breach a duty? Did you do what the reasonable person would do in the same or similar circumstances? And I would argue you did not breach your duty, because the reasonable person in the same or similar circumstances would rather hit a car than a human being. Now, I don't know what's to the left in this picture. Maybe you can argue if there's nothing over there and there's a way to swerve to the left to avoid both the motorist and the car, that's what the reasonable person would have done in the same or similar circumstances. And I'm looking up ahead in the picture, it looks like there's another lane of traffic, and maybe I'm just assuming there's another car over there, but that's really the only argument I can see. If you just have this and you assume that there's something that's blocking you from going left, like a sidewalk, and you see some pedestrians on the sidewalk up there, you're not going to hit a pedestrian. The reasonable person, I should say, is not going to hit a pedestrian, and is not going to hit somebody, a human, a motorist, a motorcyclist in the street. They're going to hit a car. So yes, it's unfortunate, Mr. White Car, that I just smashed into you, but unfortunately, I didn't breach a duty that I owed in this case. Alright, sticky situation, but that's the way I think it breaks down. You got to ask, what would the reasonable person do in the same or similar circumstances? And in some cases, the reasonable person does crash their car. Very, very slim circumstances, but that would be one of them. Causation. Okay, so breach is pretty simple. I mean, to me, it's a question for the jury, and I can't really test you on it unless we're, talking about one real extreme or the other. Something that somebody clearly did that they didn't live up to their duty, or something that somebody did where they clearly lived up to it and it's obvious. Hard to test the gray areas there. Causation is another one of the sticky elements, and we need to spend some time with this one, because we're talking about proving a cause and effect relationship, and that can be hard. Alright, so we really have two different flavors of cause, and you need to prove both of them. And we're going to talk about why we have two different ones and why that's necessary. First of all, the first flavor of causation is called actual cause. The second is called proximate or legal cause. So the defendant has to be both the actual cause and the proximate or legal cause. I don't care which one you call it. Pick one of those, proximate or legal. I like proximate because it helps me remember what it actually means. I don't know how they came up with legal or why that's a term for this, but whatever works better for you. Alright, so let's start with the actual cause. What we have for each of these, the actual and the proximate cause, is a different test. Kind of like, did the defendant breach their duty of care? Kind of like a question to ask and to think about, to whether or not they are the actual cause or whether or not they are the proximate cause. So The test for actual cause is called the but-for test, right? And it goes something like this. But for the defendant's breach, in other words, their stupid or careless act. I mean, we just established the breach one step ago, so you should know what that is. Would the plaintiff have suffered damages? Right? Now, the downside to this is that in most cases, that answer is going to be yes. All right? This is a very expansive test. Almost anybody, almost anything can pass this test. So it's almost not worth mentioning because it's so expansive. I mean, think about the example I gave you before, even though I said I didn't owe this person a duty, but the lady who sees me driving down the street not looking at my car and sees me hit somebody and suffers a heart attack, but for my careless act, would that person have... No, clearly, if I hadn't done that, if I had been looking at the road and hadn't hit somebody, she wouldn't have suffered a heart attack. So even cases that fail on other ends are going to still pass this but-for test. And at some point, the law recognized that. And remember, torts is a common law concept. So cases are coming out all the time that are kind of modifying it, extending it, retracting it, you know, all kinds of stuff all the time. So I think what happened next was the idea of, okay, how do we limit that? All right, and the case that really brought this to light, I've already mentioned it once, is the Palsgraf case. All right, so we'll talk about that after we get through the test for proximate or legal cause. All right, how we check for proximate or legal cause is another issue of foreseeability. All right, was the damage to the plaintiff a foreseeable result of defendant's conduct? So whereas before we were looking at the individual, are they when we're talking about duty, are they a foreseeable plaintiff? Think about this, you know, the people who are potentially in danger because of the conduct. Now we're talking about the result. Was the damage to the plaintiff a foreseeable result of defendant's conduct? So here's the difference. I'm driving down the street, I'm not looking at the road, I smash into somebody who's trying to cross the street, and I cause them damages. Do I owe them a duty? The answer is yes. Is the damage to them a foreseeable result of my conduct? The answer is yes. Now let's change the scenario a little bit. I'm driving down the street, not looking at the street, and I'm driving down and I'm about to hit somebody who's crossing the street, but I see them just in time and I squeal to a stop before hitting them, but they're so traumatized by that they have a heart attack and die right on the street. Do I owe them a duty? Somebody crossing the street, is that a foreseeable plaintiff from the conduct that I was engaged in? The answer is yes, I owe them a duty. Is the damage to the plaintiff a foreseeable result of my conduct? Is a heart attack a foreseeable result of me driving without looking at the road? I would argue no. There might be some other cause. Notice that in this case, it actually passes the but-for test, right? But for my breach, me driving down the street, not looking where I'm going, would the plaintiff have suffered damages? The answer is no. I wouldn't have had a heart attack if I had just been looking where I was going. So it passes the but-for test. But I would argue it fails the foreseeability test. That damage was not a foreseeable result of my conduct. Here's another one. You get into this all the time, where, now you know what, I'm not going to go there. That'll just confuse it too much. So that's enough, I think, the question of foreseeability. So back to Palsgraf. We talked about this quickly, and it's in your book. The case where the lady sues the railroad station and the railroad company. And the set of the facts is that there was an individual who was late for a train, went chasing down the track after it, and they were 30 or 40 feet down the track, something like that. An employee of the rail company reaches over the side of the train to pull this guy onto the train, and then as he's doing so, the passenger drops a package, which turns out to be, fireworks or explosives or something that goes off, which causes vibration, which causes a chain reaction of things, and then some scales or some weights of some kind fall and hit this lady, Mrs. Palsgraf, on the head, 40 feet down the track the other direction. All right, now, but for the defendant's conduct in this case, helping this guy onto the train when he was late. Would the plaintiff have suffered damages? The answer is no. So it passes the but-for test. But the point that one of the judges brought up in this case is that negligence in the air that happens somewhere can't necessarily mean that there's liability around the entire earth. There has to be a line drawn. At some point, the damages and the injuries that's caused is just too far away in time or in space in order for this person to really be responsible for it. So proximate cause, when you think of proximate, think of it in terms of closeness, right? If you're saying it's proximate to this or that, that means being close. And that means in time or in space. All right? So Mrs. Palsgraf, does she pass? She passes the but-for test. Does she pass the foreseeability test? When there's somebody pulling somebody onto the train and they should have just let them go and missed the train, is her getting hit in the head by something a foreseeable result of defendant's conduct? And I would argue that it is not. And that's a pretty distant causation. All right? I mean, that's a pretty distant one. But the thing that drives law students nuts, and the reason why they always talk about this case in law school, is that the court ultimately found that the railroad should be responsible to her. So that's kind of frustrating. But ultimately now, the way that case is looked at is actually the other opinion, not the majority opinion that said that they should be liable. The other opinion is considered the more correct opinion, which is a little weird. And that case is weird in a lot of ways, but it's a great one to illustrate the proximateness of cause. Something being too distant, not close enough, not proximate enough to the negligent act in order for the defendant to be actually liable for it. All right, so we need both of these. It needs to be the but for, the actual cause, and then but it still needs to be close enough to the defendant's negligent conduct in order to be the legal cause or proximate cause. All right, so that's causation in a nutshell. I know it's a little weird because you've got two flavors of it and you've got to find them both. But getting through the but-for test is really simple. All you really have to remember is this proximate legal cause test, and that's where sometimes things can get a little bit tricky. And understanding the difference between foreseeability as it relates to the foreseeability of a result, or the foreseeability of the damages, and then if you go back to the element of duty, the foreseeability of the plaintiff, the foreseeability of the person, them being in the zone of danger created by the defendant's conduct. Like I said, that negligence is all about learning duty and learning causation, the breach, and then, of course, the last element, damages, is really simple. I'm going to make this really simple for you. Damages just need to have some loss. It can be damage to property, and again, we're using damages in this context to mean something that you've lost, something that's been damaged. It can be your person, so it can be broken leg, broken arm. It can be you got sick. It can be property. Your car got smashed, your house burned down, someone ripped out one of your trees, something like that. All right, but you need to have some loss as the result of the defendant's breach. If the defendant's breaching a duty but doesn't ultimately cause any damages, it's the same as you seeing me drive down the street not looking at the road, but I don't actually hit you. It's not a negligence claim. All right, that's one thing that makes it very different from intentional torts. Okay, so the third flavor of torts is strict liability. Okay? Strict liability is liability in the absence, without care for what your state of mind is. So whether you acted intentionally, unintentionally, did something by accident, did something because you're stupid, it doesn't matter. Strict liability is going to apply regardless of the defendant's mental state. So that's the bad news for defendants. The good news is strict liability only applies in very specific circumstances. All right? We call it an absolute duty because it's a duty exists and it's like there's no standard to it. It's just there's no way to say I lived up to that duty. You have a duty, and if somebody gets injured, there's no living up to that duty. You're liable. So it's a standard of care that's like 100%. Make sure that no one ever gets injured ever at all under any circumstances, or you're going to be liable. All right, so that's called an absolute duty. but it only applies in certain circumstances. So for the ease of studying, I categorize these into 3 different groups, and we're going to talk about each one. The first of them being ultra-hazardous activities, and we're going to break those down to really 3 specific types of ultra-hazardous activities that this applies to. It doesn't apply to anything. You know, we can't have a semantic argument about what ultra-hazardous means. I'm going to give you 3 things. Those are the ultra-hazardous activities, period, end of story. That'll make it easy for you. Number 2, my second favorite Pink Floyd album, Animals. Unfortunately, it actually has nothing to do with Pink Floyd, but with certain situations involving animals, there can be strict liability, and we'll talk about what those specific situations are. And third, products liability, but not any products liability matter. And we'll get into products liability in a little bit of depth and talk about that, but it's not for any kind of product. It's only for unreasonably unsafe or unreasonably dangerous products, and we'll talk about that in some more detail in a minute. But let's get started with the ultra-hazardous activities. Okay, so we're going to categorize these ultra-hazardous activities into a couple different groups, and I'm telling you, it's limited to these things. Nothing else, for the purposes of our course, can be argued to be an ultra-hazardous activity. Only these 3 things. Number 1, handling explosives. All right, so this is something that a lot of businesses have to do at some point. Like this guy, for example, needs to blow up trees. I don't know why. I found this picture. I thought that was a little peculiar, but apparently for some reason cutting them down just isn't going to get it done. So he's strapping dynamite to these trees, and they are going to be blown to sky high. I don't know what's going on here, but clearly he's got a hard head on. He seems to know what he's doing, but when you're handling explosives, you have an absolute duty to make sure that absolutely no one gets injured from your use of those explosives. So, you know, over down part of the state near where I live, we have a couple of rock quarries, especially in the Westbrook area. And when you drive by them, the quarry itself is, I don't know how many feet away from the street, but it's a long way back. It's set way back from the street, and there's usually at least 2 layers of fencing. There's one fence, and then, you know, maybe 30 feet past that, there's another set of fences. And the truth of the matter is, strict liability applies. So if anybody gets injured as a result of their use of explosives, they're going to be liable, right? So I don't know what's going on here, but there's some more explosives. You know, all these warning signs in the world aren't going to make a difference. Warning people that it's going on, I mean, there's very little assumption of the risk that can take place when you're talking about a strict liability situation. All right, and I just think that's awesome, so I wanted to add that in here too. So you see somebody handling explosives for the purpose of this class. It doesn't matter how careful they are. It doesn't matter how many warning signs they put up, or fences. Using explosives, strict liability applies. Somebody gets injured, you're going to be liable. Strict liability, period, end of story. All right. The second category of ultra-hazardous activities is radioactive materials. All right. That's some high-grade enriched uranium right there, used for nuclear power. And of course, as a result of the use of radioactive materials for nuclear power, we have nuclear waste, which has to be transported. It has to be disposed of. And if you're handling radioactive materials and somebody gets exposed to that, period, end of story, you're going to be liable. It doesn't matter how careful you are. That's going to be it. All right? It doesn't matter how many signs you use. I mean, it's a good idea to put up signs. I'm not saying it isn't, but it's not going to save you from liability. The businesses that have to handle these, now this is a little small. Maybe you can't see it, but there is a little radioactive sign right there. So this is actually the transportation of radioactive materials. And concrete is a great substance to store radioactive materials in because it holds the and lead. Usually there's lead lined inside those concrete containers because it contains radioactivity much better than, say, plastic. This is a dangerous industry to be in because strict liability applies. And the last one, dangerous chemicals. All right, used in a lot of different contexts. All right, this guy here appears to be spraying pesticides, but look at the precautions he's taking as an employee, theoretically, doing that. And if somebody gets injured due to their use of a dangerous chemical, strict liability is going to apply. Again, it's something that needs to be transported. This picture is actually from a shipping container. in which apparently toxic and corrosive chemicals are being transported. And again, signs and things like that, warnings about dangerous chemicals is not going to save you. So to illustrate this, I have another case that I really like to show. This actually took place in Rhode Island, I think. And there was a building that was basically a two-part apartment building, and splitting up, like an A and B, if you will, two towers to the building. And in between the two, they were built together, but in between the two parts of the building was an impenetrable firewall they wanted to do, so that if there was ever a fire on one side of the building, it would be contained to that side of the building, and they wouldn't have to, it wouldn't go to the other part. But of course they didn't have a fire. What they ended up having was some kind of infestation of some pest. So the people on one side of the building complained about it, and the owner of the building said, all right, we'll send in some people to go check it out. So a company came in and said, yeah, you've got a real bad infestation here. We're gonna have to spray or bomb, some kind of chemical or whatever. And they said we should evacuate the whole building. And the owner said, well, I think we'll be okay, because people on the other side of the building, there's this impenetrable firewall that can't get through. And so even if there were, if this other side was being fumigated, it wouldn't interfere with the other people, would it? Because A, they don't want to leave, and B, I don't want to have to pay for it, put them up somewhere else, like in a hotel, while the building's being fumigated. So the company said, well, let us take a look at it. And as best they possibly could, they got in and took a look at this firewall and said, all right, we'll be okay. And they did everything they could to inspect that, to make sure it was safe, to make sure it was airtight and all that stuff. But ultimately they concluded it was, and they did their spraying. Leaving one side of the building occupied, the other side that they were spraying evacuated. Wouldn't you know that a week or so after the spraying, the people on the side of the building that did not vacate the building started getting sick. And doctors determined that it was because of exposure to the chemicals that they had used to address the pest problem on the other side of the building. And so the people who got sick sued this pest control company and said, this is your fault because you used a toxic chemical, and there's strict liability because that's an ultra-hazardous activity. And they responded and said, we were 100% careful. We looked at every study of the building. We did everything we could to make sure that it was safe. We relied on the opinion of the owner, who told us that it was airtight and it was a firewall. We didn't do a thing wrong. We were careful in every single thing that we did. How can we be responsible for this? How can you say this is our fault? And the answer that the court gave them was, well, it is, because you're handling dangerous chemicals and strict liability applies. Period. End of story. All right, so tough situation to be in for a business, a strict liability situation, but that's the way it goes. So that's ultra-hazardous activities. We have three categories: explosives, radioactive materials, dangerous chemicals. If you see anything other than that, it's not an ultra-hazardous activity. However, that's not the only thing that strict liability applies to. We need to talk about animals. Now, the first category of animals that can be potentially a strict liability scenario is trespassing cattle. All right, we talked about trespass to chattel, and in intentional torts. Now we're talking about trespassing cattle, and that's literally what I mean: cows and other livestock that get loose. This is obviously a very old sort of common law rule, because I guess it still does exist in some places now, but this isn't an enormous concern anymore. But the rule, I guess we'll say for our purposes, is a general one and still applies. If you have livestock that gets loose, you are strictly liable for whatever damage they cause wherever they go. Alright, that's a strict liability scenario. So we've got some cows over there that seem to have taken over a neighborhood, and over here we've got sheep, some of whom are brave and have left the friendly confines of their area, and of course the other sheep are just being sheep and staying where they are. And I love the picture of this guy, because he's a punk cattle. I mean, look at that haircut. He's just like, dude, I am not going to conform. End of story. So when you have cows like that have like those emo haircuts, you got to watch out for those guys. Hipster cows, you got to watch out for them. They are not going to conform, and if they trespass, it's going to be your responsibility. I mean, look at that guy. He doesn't care. He does not care at all. All right, let's move on. The other area where animals can apply, domesticated wild animals. All right, what are we talking about? All right, you've got little Scruffy here, and he is a really upset sort of dog, and he goes off and he bites people. Liability? Yes. Strict liability? No. We're not talking about your dogs and your cats and rabbits and stuff like that. If they go nuts and they bite people or scratch people, it doesn't mean that you can't be liable. It just means it's not strict liability. We're talking about, and I can't even believe this picture exists, we're talking about this. If you've got a tiger for a pet, which just don't, but if you do, and that tiger one day decides to go tiger and maul somebody, you're responsible because you're trying to domesticate a wild animal. This picture absolutely blows my mind. If you can see just over the tiger's head, there's even a small baby in this family, and yet they think it's cool to keep this tiger. All right? I mean, maybe it is, but the point is, if somebody gets hurt by that, especially outside their family, it doesn't matter how careful they are, it doesn't matter how wonderful and timid and medicated that tiger might be, if they've taken off his claws, if they've taken out his teeth so that he can't possibly bite anybody, it doesn't matter. Anything that happens, whether he gets loose or whether somebody comes to their house and he bites them while they're at the house, whatever happens, they're going to be strictly liable for it, period, end of story. You cannot domesticate wild animals without subjecting yourself to strict liability. And again, that's just an unbelievable picture to me right there. So, yeah, I'm just going to move on. Okay, so the third category, right? We had ultra hazardous activities, we had animals, and now we have products liability. All right? Products liability is a very broad area of law. It involves any damages caused by defective products in the ordinary stream of commerce. So this is a lot of the lawsuits that we hear about. I mean, I'm thinking maybe it was like a decade ago that I think it was Bridgestone Firestone got sued, products liability, because the tires that they were putting on some SUVs were blowing out and flipping the cars over, and people were getting hurt. Products liability case. A case that we're going to talk about, hopefully, on the message board is part of the assignment, the classic McDonald's coffee case, where the lady orders a hot coffee, spills it on herself, and burns herself. Products liability case. All right, so anytime you see somebody damaged by a defective product in the ordinary stream of commerce, it falls into this very broad category of products liability. Now, not every case involved, let me back up for a second. Not every case involving a products liability is a strict liability case. All right, so before you think that the McDonald's coffee case was a strict liability and McDonald's couldn't defend themselves, that's not true. And same thing with Bridgestone Firestone. So that's not the case. Only certain cases fall into strict liability, and we'll talk about that. But one of the keywords here is that it be a defective product in the ordinary stream of commerce. Right? So if you go to Bed Bath & Beyond and you buy a really, really sharp set of kitchen knives and you bring one home and you're slicing an onion, you accidentally slice your finger, you're going to have a hard time arguing that that knife is defective because it's a knife. It's meant to cut things. So people get really annoyed at some of these frivolous lawsuits because they say, how are you going to sue somebody when, it's your stupidity and your own fault? But it's the question of defective when it comes to product liability that people kind of misunderstand. So defective can mean two things. It can either be a design defect, which means the product that caused the injury was made and built exactly how it was designed to be. It's just part of that design that sucks and is causing injury, right? So when you have the gas tanks on the Ford Pinto, that if the car is rear-ended in a certain way, the gas tanks explode. It's not because that gas tank, that one, had something wrong with it, or that accident was done in such a way that it caused it. The design of that car and how they where they located that gas tank was the defect. Right? The other type of defect is a manufacturing defect. This is where one product comes off the line and is not done properly, and which makes it defective. All right? So one example of a manufacturing defect would be, you hear horror stories about people drinking cans of Coke and they hear something inside the can and they look in there and there's like, a dead mouse in it or something. All right, that would be a manufacturing defect. Cans of Coca-Cola are not designed to have mice in them. That's a one-off, a manufacturing problem, something that went wrong in the manufacturing process on that particular product that entered into the ordinary stream of commerce that had a defect to it that made it defective. All right, so we look for both of those kinds of things. I would say that in these cases, I guess you could argue that the Bridgestone Firestone case is a design defect, and maybe, depending on how you look at it, I think the McDonald's coffee case is also a design defect case, but it could potentially be manufacturing depending on what that one McDonald's store had done with it in that case. I don't know that we have enough facts to really decide, but I tend to lean more towards the design defect thing. We'll talk about it a little bit more on the message board, and we'll see why. Okay, so we need a defect, whether it be a design or whether it be a manufacturing defect. Okay. Oops, what's going on here? There we go. Okay. So, in products liability, again, not every case is going to be a strict liability case, but when you have a defective product, whether it's a design defect or manufacturing defect, the plaintiff has a number of theories under which they can recover for their injuries, their damages, because of that product. All right? And again, usually, from a practical standpoint, as an attorney, you're going to try to claim in your complaint as many of these different theories as you can. You're gonna these are each causes of action for products liability, each ways that you can recover, each sets of facts that allow for the plaintiff to have a recovery, and you're going to try to argue them all to try to get some type of recovery. So some of them might be more feasible than others. So first, these are going to sound familiar. The first potential theory for recovery is an intentional tort. If you can argue somehow that the defect is a intentional defect, designed and intended to cause that harm. This is really sort of weird and strange and odd, and I don't actually know of any real-world example where this has been the case. But if I put on my, sort of Dr. Evil hat for a second, I can see a scenario where, say, a pharmaceutical company is putting a product out there to treat something like a headache, knowing full well that it causes this other disease or illness, that their pill for the headache causes another disease or illness, which, oh, by the way, they also have an exclusive cure for. So they're intentionally putting a product out there that has a design defect, and the reason they're intentionally doing that is because they have some profitable benefit on the other end by selling more of the cure for the side effect or the other thing that they know that this causes. That, to me, would be a products liability intentional tort case. I'm not aware of anything like that ever having been brought. I could be wrong. I haven't done the research on that in a long time, but I suppose it's possible, but God, I hope not. That sounds horrible. More likely, whoops, here we go. More likely, you have a negligence theory, right? Think about the can of Coca-Cola. I don't think it was intentional that they put a dead mouse in the can. Probably it was just negligence. Somebody, was careless or stupid. I mean, that's how that happened. Somebody didn't do their job. The quality control wasn't good enough, and as a result of that, there was a harm caused. The strict liability one is what we're going to come back to, because obviously that's what this section of the torts chapter is all about. But again, it's not for all types of products liability. It has to be an unreasonably unsafe or unreasonably dangerous product. But the last one, just worth mentioning, we haven't talked about the Uniform Commercial Code yet. When we do, we're going to talk about warranties. This is sort of the last-ditch effort to maybe get some money for your client if it's a products liability case. Because this is a contract claim, it's not a tort claim. And when we talk about contracts, you know that the damages are based on a theory of making the plaintiff whole, making the plaintiff putting the plaintiff in the situation that they would have been in if the defendant had performed the contract. Whereas torts goes beyond that. It's not, if you have a lawnmower that, is defective in some way and chops your arm off, they don't try to put you in a position so they, if the product wasn't defective, so give you your arm back in a new lawnmower. They want to compensate you for all the damages, all the loss, future loss, pain and suffering. That's why torts has a much broader recovery of damages than contracts, which is why attorneys, when they're doing products liability, are going to try to do strict liability or negligence or intentional tort if it's available. It very rarely is, obviously. But if it's out there, they're going to go after that before they, say, well, worst case scenario, I'll get my breach of warranty because the product itself breached what it was supposed to have been able to do. And we'll talk more about the Uniform Commercial Code and warranties under that when we get to that section. So let's talk about strict liability in products liability. It only applies where the product is unreasonably unsafe or unreasonably dangerous. Right? Here we are again talking about reasonability, which every time you hear reasonable, the one thing that has to enter your mind is that it's a question for the jury. What is and is not reasonable. So very hard for me to tell you and give you like a black and white explanation of reasonable and not reasonable. It's something that has to be kind of weighed out and played out by a jury. But I'll try to at least give you a feel for things that this is clearly not reasonable and this is clearly on the other end. All right? But for our purposes, what we mean by that is it's got to be dangerous way beyond the consumer's expectations. So let's come back to my knife scenario. You go to Bed Bath & Beyond and you buy a really sharp set of kitchen knives. And guess what? They're really sharp. But is that beyond your expectation? No, you should pretty much expect that. Those are your expectations. So I wouldn't say that those knives are unreasonably unsafe. Are sharp kitchen knives unsafe? Absolutely they are. They can cut people, they can kill people, they can cause serious damage. But they're not unreasonably unsafe. Right? Because if they were selling dull kitchen knives that don't cut anything, you wouldn't buy them. And you have to expect that they're going to be sharp. That's part of the reason probably why you want to buy them. So that's one part of it. The second part of it is that there was a less dangerous alternative, was economically feasible. Let me give you one of my favorite cases involving this. Guy buys a lawnmower. And if you own a lawnmower, by the way, take a look at it. And I guarantee you, at the location where the lawnmower expels the cut grass, there's going to be a piece of plastic, probably about maybe 6 inches long, covering the opening where that grass comes flying out and where the blades are. And the reason why you have that covering is because some guy, you know what happens when you're cutting grass? Sometimes grass can kind of get clumped up inside the area where the blades are spinning because your grass is wet and can stick together, so you get that. So some moron decided that he needed to clean out some of those clumps, stuck his hand in that hole to clean out the grass, and of course the lawnmower did a number on his hand. So he sued the lawnmower company for products liability, saying that the lawnmower was design defect, unreasonably unsafe. And the lawnmower company said, hello, it's a lawnmower. It shouldn't be beyond the ordinary consumer's expectations that it be sharp and that it has spinning blades. And the response from the plaintiff was, no, it wasn't beyond my expectations that it'd be that unsafe. However, a less dangerous alternative was really economically feasible, and you should have employed it. All right? And his argument was, all it would take is a 6-inch piece of plastic that would make it the blades a little bit too far away for me to get a hand under there. That's all it would have taken. And they had a full market analysis and a product analysis, and they presented all this information to say this material to make this would cost pennies per product. It would take no time to put it on the product. You would sell exactly the same amount of lawnmowers, from a business standpoint, from a financial standpoint, from a customer service standpoint. It is not a problem. It was completely feasible and should have been done. And remember, when we're talking about reasonability, It's the jury's question to answer. And the jury said, you're right. A less dangerous alternative is economically feasible. Therefore, this product is unreasonably unsafe. And that guy won. And that's one of the things that drive people nuts. And they say, how can you stick your hand into a lawnmower and get it chopped up and then say that's your fault? And I give it to you, that one is kind of a weird one, but I still stand by that case as being correctly decided, and it's correctly decided because a less dangerous alternative or a fix to make that so much more safe, you know, the amount of safety that that small piece of plastic provides is off the charts compared to what it costs. So you have to kind of do a cost, it actually requires you to do a cost-benefit analysis on what it would take to make the product safe versus what that costs. So in order to make that knife safe, you'd have to dull the knife or put some kind of plastic covering on it that would make the knife basically useless, and you wouldn't sell any of them. So the cost might be low, I don't know, might lessen the cost actually, but it makes the utility of that knife drop off the charts so much that it's not economically feasible to make that change. However, with the lawnmower, the cost of adding that little piece of plastic onto it is so low, and it makes the product exponentially safer, that it's actually a really good idea. All right, so a sticky one, I'll give you that, but that's the way it works. And an important thing in here too to remember is this or. Right? It's not, you know, think about the lawnmower case. I mean, yes, it might have been within the consumer's expectations that those blades be dangerous, but but that's not necessarily the one where he won. He won down here on number 2, that the less dangerous alternative was economically feasible. So it's or, it's not and. It's one or the other. All right? So that's products liability in a nutshell. But I do have one last topic to cover with you before we're done with torts, and that's vicarious liability. Now, we haven't done employment law yet in this class. We're going to get to that towards the end of the class, and this is something we're going to come back to again because this, and agency as well. We're going to do employment law and agency, and we're going to come back to this again when we get there. But the idea of vicarious liability is being liable for someone else's tort, and that's a weird thing. That guy over there committed a tort, and you're the one who's going to be liable for it. That's difficult to understand, and again, it's kind of like strict liability. It kind of stinks for you, but the good news is, just like strict liability, it's based only on certain circumstances. It doesn't apply to everybody, and it needs to have a certain relationship between the one committing the tort and the one who's going to be liable in order for it to apply. So the biggest one, like almost the only one, like this is the huge example of this, is the concept of respondeat superior, and we're going to talk about this in a lot more detail when we get to employment law. But the concept here, just generally, I'll just mention it really quickly, is that an employer will be liable for the torts of an employee if they were committed in the course and scope of employment. All right, what does that mean? It means that if you're working and you're doing your job, then and the tort happens within the course and scope of employment, then it's going to be the employer's liability, not yours. So you're a pizza delivery person, you're on the job, you're going to a house, and you drive negligently and you crash into somebody else and they want to sue, they can sue Pizza Hut or Papa John's or whoever for that tort because you're an employee and the tort was committed in the course and scope of your employment. You're a pizza delivery person and you take your car home on the weekend because you deliver with your own car, and on the weekend you happen to crash into somebody when you're off duty, they're going to sue you personally. And if they try to sue Papa John's and say he's an employee of yours and he drives his car at work and he crashed into me, Papa John's is going to say he didn't do this in the course and scope of his employment. He was off duty and off hours. We're going to play with this a lot more in a lot more detail when we get to employment law, because course and scope of employment isn't necessarily defined by being on the clock or off the clock, and it's not defined by what's your job description. Like an example I like to use is if you work on the sales floor at like the Gap and you're folding t-shirts one day and then somebody says, "Hey, stop that guy, he's stealing something." and you decide to go all vigilante and you decide to, tackle that person to stop them from stealing some merchandise, and you injure them in the course of tackling them, and they want to sue the Gap's not going to be able to hide behind that and say, well, it's not in the course and scope of your employment to be stopping theft. You're just a sales, clerk or whatever. That doesn't necessarily fly. It's not defined by the job description. It's defined by something else. It's defined by acting in the best interest of the employer. So in that case, the Gap case, you were. In the Papa John's situation, when you're off duty and just driving your car, going to a friend's house or something, or going to the beach, and you get in an accident, you're not in that case doing anything in the best interest of your employer. You just happen to be driving your car that you use for work. Even if it was a company car at that case, and you took it home for the weekend and decided to be a bad employee and take that company car to the beach, just because the company owns the car doesn't mean you're in the course and scope of your employment. You're still not doing something for the best interests of your employer, so it's not going to apply. So employer-employee is one of the relationships where vicarious liability can apply, if it's a respondeat superior situation, and principal-agent as well. Alright, so we'll talk about agency and when an agency exists and when it doesn't, but same kind of concept. Principal is like the employer, agent is like the employee, and that's going to apply in that. Also, when we get to talking about business organizations and when we talk about partnerships, that's another situation where vicarious liability applies. If you and I are partners in a general partnership, I can be liable for your torts committed in the course and scope of the partnership. Alright, so if you're home on the weekend and you crash into somebody and it has nothing to do with the partnership, that's not going to be my fault. But if you're doing something, like, you don't see many law firms put together as general partners anymore, because any one of the general partners can be liable for the other one's legal malpractice, and that just doesn't provide a very good layer of safety for the business. So you see them organized as LLPs or other things. So that's vicarious liability, and we're going to talk about that. And it's always based on the relationship. You always have to look for the relationship before you decide whether or not it applies. But we're going to talk more about that when we get to employment law, because the big elephant in the room is this respondeat superior concept. And we'll talk about some cases as well that illustrate it. Okay, so that's pretty much what I've got. Here's the deal going forward. That's tort law, kind of in a quick nutshell. I'm going to be posting some discussion board material, some things for you to review and comment on. I'd ask you to participate in that. That's how we're going to be sort of taking attendance for this week. So please do get involved. Please do play your part. And it's also kind of a class participation sort of element to this, because just getting on the message board and typing, yeah, I totally agree. Yes, technically you satisfied the requirement of attending and participating, but as far from a class participation standpoint, I don't consider that very high quality participation. So think about that. Whatever I post, put some thought into it, put some effort behind it, and try to reply to each other's posts as well. I mean, don't just wait for me to chime in. I think these things are best explored through group discussions, so let's get one going. In the meantime, thank you very much for your cooperation through this and for listening. I hope it wasn't too horribly boring. And any questions, also please post those to the message board, or you can email me, and I'll always be quick to respond. So thank you again. Look forward to seeing you guys in class soon.